Hello, ladies and gentlemen. This is William Keat of lawandalchemy.org and commonlawconstitution.org. So, welcome back. We're carrying on with the series on the essentials of the British Constitution, and I think we're now on to Part 7. So this is this section here, the dangers of suffrage, majority and consensus. And this is a really important one, and it's a bit of a knotty one, so there's going to be some definitely some explanation to expand this a little bit. But what we're really looking at in this section is compared with where the Constitution wanted us originally, where have we got to in our governing system? Because it's quite a different place that we're in now. And so we're gonna look at that and the nature of that governing system that we have now compared with how it was meant to be under the Constitution. But let's get straight into it and start reading it. Okay, so the dangers of suffrage, majority and consensus. It is worth laying out some thoughts here about the inherent dangers of these concepts of majority voting and consensus thinking. Too often people are fully bought into the mindset that somehow the opinion of the greater number must hold greater value in some way. This has to be one of the most dangerous and powerful mind control tricks ever played on humanity. Over time, most people have come to believe that majority voting is the only concept in existence for bringing fairness and justice into our society. The concept of majority voting is not embraced by our common law with the same fervour or enthusiasm as we do in our modern mindset. All this does is create a consensus, the opinion of the lazy majority who have usually taken the easier path of less resistance. Truth is often uncomfortable and takes more courage to face. It often hides in dark corners or under the carpet following a furtive sweep. But the thinking man will resist the temptation to adopt the opinion of the herd. Instead, through quiet reflection, patience, or even courage and determination, arriving at a more carefully considered position. One could easily argue that the nonconformist's perception is often closer to the truth. How many times are we suckered into that automatic belief that the majority must be right or correct? Once considering this carefully, one could claim that the truth is more often held by the minority. And I've quoted Søren Kierkegaard at the bottom there. Truth always rests with the minority, and the minority is always stronger than the majority, because the minority is generally formed by those who really have an opinion. Okay, that's quite interesting. We'll just expand on this a little bit. Just one more sentence. Therefore, what makes one think that a system of voting designed to reward the majority with an automatic victory is considered preferable? Wow, so there's quite a lot to unpack there, but I think you get the point. So what I'm exposing in there is the dangers of this idea that just because a larger number of people think this thing, they must be more right or they must have greater insights than this smaller group over here that think the other thing or something different. Okay, so that is quite a concerning truth when you arrive at that and you realise, my goodness, the possibility that actually often it's the smaller number that often have greater insight and perception into an issue rather than the bigger majority. And it's quite obvious when it's pointed out, and you can see how that would be the case. And yet, horrifyingly, there we are. We have our modern political system completely based on this idea that, well, whatever more people think, that's the thing we're going to go for, right? So the Constitution actually recognises this, and we're going to come onto this in just a minute. That'll be the next thing that we deal with. But what we're actually talking about here with this kind of majority voting is something called adult suffrage. It's not actually what everybody thinks it is, which is democracy. Everybody thinks that that's the thing that makes up democracy. but it isn't. And we've already dealt with that in an earlier section, that democracy is actually about something else. It's about trial by jury. It's about the sovereignty of the people to be the final arbiter of law every single day all over the country. Yeah, that's democracy, because that's the people ruling. Yeah. But this, what we're describing here, is adult suffrage, and there's a huge problem with this. Any society that's based on adult suffrage, you're going to get problems, because it's about groupthink. It's about majority consensus, and that's a problem. So let's continue, because there's some more insights into this. So where do we get to here? Is it not the minority that shapes the world? How interesting it is, then, that it only takes one member of the jury to acquit a man. The common law truly favours the thoughtful single juror. Truly a system for the contemplative minority. Right, so that's interesting, isn't it? So there we go. I was talking about that just there, that our constitution, which is really all about authentic trial by jury, that system, it doesn't look at the majority thing as a value. Yeah, there's no merits in the thinking of the majority, and it recognises that principle. So carrying on. Now this is opening up the whole adult suffrage to an even grander scale, which is where it gets even more confusing. But this is one of the traps that people fall into, sort of campaigning movements and people who are concerned about liberties and freedom often talk about, well, let's move to a system of referenda. Okay, so this next section is dealing with this. Have a listen to this. There is more to this, however. Many are tempted to take suffrage and the concept of majority to the next level with referenda, by asking all citizens individually about one specific issue or policy. And although this again fails for the aforementioned reasons, as it is still based on majority, there are further dangers that go completely unrecognised. Asking the nation about measures or policy by putting it to a vote will not grant the citizen an opportunity to reflect deeply on the effects and reality of the proposed legislation. But put before a common law jury, where the jury is deciding on the justice of the law, you are placing the proposed legislation under real scrutiny, with the added benefit of seeing its effects on a real man or woman potentially facing punishment, actually playing itself out in front of the court. The jury are using their conscience whilst judging the effects of the legislation on the accused man, who could be going to prison, for example. Motive, context, and state of mind are all being considered carefully, and thus the law is being examined in a veritable petri dish, in a justice laboratory. Last paragraph. The fairness of a proposed measure could not receive a more painstaking and meticulous examination, surely, as it does in the context of the common law trial by jury, the foundation of our constitution. Well, it does make an interesting point, that, doesn't it, to do with this idea that simply putting things whimsically out to the nation, a policy measure out, and I'm going to talk about policy more in a moment, out to the nation without seeing the effects of that piece of legislation actually on a man in court, right? That's the real value, of course, that comes up with trial by jury, is that you're not only judging the man himself, but you're also judging the piece of legislation that essentially brought him in, and you're doing it at the same time. Yeah, so you're weighing that up together, and it's that bringing together that process that is the real value in trial by jury there. But just whimsically putting a piece of legislation out to the nation when they haven't got the realities of it, that they can't face that and see that, is not going to have the same effect on bringing about matters of justice through their conscience. Doesn't work the same way. So that raises some important issues. Now, there's another thing that I just want to bring up here, which is not quite made as clearly as I would like in that document, and maybe I should add it in, is where we've got to in this travelling from the Constitution to this business of the fact that we have a huge amount of legislation in play today, because it's very different. So what we've actually got under the Constitution originally is justice, which deals entirely with matters of equity and free will, through conscience. We're judging morality. We're bringing out about proper organic justice according to our organic consciences, right? That's really what the Constitution requires, But if you think about what's happened now, and quite recently, we're only talking within the last 300 years or so, is that they've conflated the bringing in of a prime minister into office, which, by the way, is an aspect of democracy where we do vote in elections, but it's just a minor characteristic of democracy. We use voting to bring people into office, to bring a public servant into office. That would be using adult suffrage. But then those public servants are then required under the Constitution to uphold and support matters of proper justice by supporting the system of trial by jury, the constitutional principles. So adult suffrage is still used. It's a minor characteristic of democracy, but the problem is that they've conflated the two. By bringing the Prime Minister into office, what you're actually doing is bringing in a party into office that put in place or put out a manifesto or a package of measures that they want to then roll out as central policy within our system. So what you've now got is 51% of the country, or whatever it is, and then you've got the rest who didn't necessarily vote for them or want that, divided up as different, potentially different potential parties. And the 51% get their policies enacted. But what's happening now is that everyone is now being expected to comply under those policies. So it's no longer really a matter of justice. It's not really about morality anymore. It's, we're going to put in place this measure, and only 51% of the country actually wanted it. The remaining people now have to comply, but are being potentially told that if they don't comply with the thing that they didn't want in place, that they're being immoral. No, because morality doesn't change. It's determined by it's determined by the universe. Okay, morality is all about free will and equity. Okay, it's not about whimsically what one party decided that they wanted to put in place. So what we're really getting at now is a system of order following. So if you don't comply with that piece of legislation, then you're basically you're immoral because you're not following an order. And I think that we learned at the Nuremberg trials that simply following orders is not a good thing to do, because you're not exercising your moral conscience. So we're getting into some deeper aspects here, but what we're really saying, boiling this down, is our governance of this country has gone from courts of conscience dealing with proper justice and morality, and it's travelled to putting in place a series of policies that you are now expected to follow, and if you don't comply with those, then and you don't follow those orders, that's essentially what it is, then you will be punished. That's not proper justice. So that's what we've ended up at, and I just wanted to clarify that because it's quite a knotty and complex little issue that to explain, but I'm sure you get the gist of it. So that was a chunky little section, that one, quite tricky, but I hope that was useful, and I hope that clarified some things for you. The next section is about usury and our money system, so that's part 8 coming next. Hope you enjoyed that, hope you found it useful. Cheers for now.